The Division 4th Department. Hear you, all persons having business before the court. Draw near, give their attendance. Judge Jury.
Good morning. Welcome to the Appellate Division 4th Department. Just a couple quick reminders. Number one is that the judges really make an effort to study the briefs and records, and we're familiar with the facts, so we don't need a recitation of the facts unless we ask for one. We also ask when you come up that you really get to your contentions right away, and if you can, highlight your most important contentions for us. Lastly, most of you know we don't allow rebuttal, but we do allow post-argument submissions if you ask for leave. With that, I think we're ready to go. First case for argument is number 322, People versus Zubic.
Good morning, Your Honors.
Good morning.
Leah Farwell, may it please the court. Leah Farwell for Appellant Travis Sukic. I will
You have to speak up.
speak up. Okay, I'm sorry, Your Honor.
That's okay.
I've never been told to speak up in my life, so I will try.
So nobody can hear anyway.
I'm first, I will address point one of my brief, and I think it's important here for to highlight that in my brief and in this argument, I believe that the plea negotiations and the appeal waiver are two separate and distinct negotiations, I will call them. And examined under a contractual lens, plea negotiations appear to fulfill every requirement of a contract. An offer is made by the district attorney's office. Defendants are free to accept or reject that offer. Often there is bargain for consideration. The defendant receives a promise of a bargain for sentence and the people forego trial. However, the issue arises where the defendant is required to sign an unbargained for mandatory appeal waiver, forfeiting a fundamental right forfeiting his right to appellate review, a fundamental right.
Counselor, is this where in your brief you make the argument that he received no consideration, so to speak?
Yes, Your Honor.
But didn't he receive a concurrent sentence?
Yes, Your Honor, and I believe at sentencing, the judge did make note that as consideration for this sentence, you received concurrent sentencing, or I'm sorry, for this plea, you received concurrent sentencing. However, it is my argument that the appeal waiver itself is a separate and distinct negotiation, and that it should not be a condition of the plea. And
You can never be made a condition of a plea, or only if there's specific consideration for that condition?
exactly, Your Honor, only if there is specific consideration for that.
To my knowledge, that would be a sea change in our law. To my knowledge, I don't think the Court of Appeals has required that kind of specific consideration for the waiver of appeal. So you're asking us to chart a new course, so to speak.
Yes, Your Honor, I understand that, Thomas is very good law. However, I think that the Court of Appeals is aware of this issue. And in my main brief, I quote a dissent from the Court of Appeals from, I believe, Chief Judge Wilson, where they really highlight and point out this issue. And particularly here, where Mr. Zukic receives the maximum allowable sentence of imprisonment for an A felony on both counts, it cannot be said that he received any valid consideration for that waiver of his right to appeal.
We're gonna have to really think about that.
Yes, Your Honor, I understand, and I know it is a new argument, and you've been on appeal waivers, but I really urge this court to look carefully at the issue, because I think it is important here. But if there are no further questions.
Counselor, as I understood your argument here, your position is that although the court followed the model colloquy, the written waiver creates some confusion.
Yes, Your Honor.
And your position is that the defendant couldn't at one point agree to waive certain rights, but then in the written waiver, give up his entire right to appeal.
Yes, Your Honor. And I think that goes to voluntariness of the plea, actually. and a knowing and voluntary waiver of his right to appeal. And
So under the totality of the circumstances here, you'd say that this written waiver would undermine, so to speak, the model colloquy. That's your
Exactly.
position. Because you have to get past this to get to the suppression issue, right? Otherwise,
exactly.
we don't go there.
Yes, Your Honor. And I think it's important to acknowledge that although the model colloquy is orally given to the defendant and they're sitting there, they perhaps are listening, perhaps not. The last thing they do is sign the written waiver that kind of undermines the oral colloquy and does indicate your waiver of all appellate rights. So if that is the last thing the defendant is looking at, I think it creates some confusion when they have just heard the model colloquy and then they have this piece of paper that they're being asked to sign in front of them that says you waive all rights.
It says I'm giving up the right to appeal.
Yes. Yes, Your Honor. And if there are no further questions, I will rest on my brief. Thank you very much.
May it please the court, Michael Hillary for the people. I'll address, unless the court has another approach, I'll address Judge Del Conte's concern with the written waiver first. Like the oral colloquy of the court, the written waiver starts with the basic rule, which is that the defendant is waiving his or her right to appeal with the plea and then moves on to exceptions to the rule. So the general rule is, yes, you're waiving your right to appeal. The specifics here are that the defendant will retain the right to appeal certain issues. For example, the voluntariness of the or the legality of the sentence or the court's jurisdiction. Those are non-waivable, and both of those are apparent in the oral colloquy of the court and the written waiver.
Mr. Hillary, do you think, I'm sorry.
Go ahead, Judge.
You're familiar with Thomas, obviously we all are.
Yes.
Bassano, came out after that. And then more recently, Appia. My question is, do you think given Bassano and Appia, where Bassano seems to require that if there's confusion, this is my paraphrase, if there's confusion as part of the plea, the court has to affirmatively correct it with respect to the breadth of the appeal waiver. Do you think given this language and this written appeal waiver that to my knowledge your office continues to use, even after Bassano, do you think that the court has an obligation to look at this language that seems to be conflicting and explain it to the defendant?
I think the court has an obligation always to ensure the defendant's basic understanding of the plea and what he's being asked to waive. And I think that in the specifics, when the court addresses a defendant and says, do you understand? Do you have any questions about this waiver? Have you discussed it with your attorney? And the defendant repeatedly says, yes, I do understand. Then the court has the wherewithal to receive that as a knowing and voluntary and intelligent plea.
Counselor, when the defendant signs a waiver and the waiver says in paragraph 4, I'm giving up the right to appeal. If that's not an accurate statement of the law, is it, Counselor? I'm giving up the right to appeal.
He's giving up the right to appeal with exceptions. So I think what the colloquy or what the oral and written colloquy are doing together is starting with the basic premise, which is that everything that you could do.
I understand your argument. I'm asking you about what the waiver says. In
Right.
paragraph 5, the waiver goes on to say, I'm giving up the right to have any court review my case. Is that an accurate statement?
It's in and of itself, Judge, it would be inaccurate. In and of itself, it would require some kind of revision. And I think the revision comes in the follow-up paragraphs to that provision. The courts recognize that imperfections are going to be a part of the language in the dialogue.
Let's just stay with that because the
Okay.
following paragraph says, I understand the waiver includes all aspects of my case, including the severity of the sentence. That following paragraph doesn't carve out any exceptions, does it?
If that's all we had in that colloquy, then I would have no argument. I would agree. It's unacceptable. It muddies the reality of what the defendant is actually waiving. But again, I believe that we're starting with a basic rule, which is really almost exhaustive. I mean, there really are very few, and this is the Court of Appeals zone language, for instance, there are very few issues that survive a valid appeal, a bargain for waiver of appeal. And typically the courts mention the same 3 or 4: legality of the sentence, voluntariness of the plea, jurisdiction of the court. I believe those were the 3 that were mentioned here in this case. So if you didn't have that subsequent carve out, then I'm in full agreement with the court that there is sufficient ambiguity here, that the court was under some obligation to clarify that.
Just to follow up further on that paragraph 5 of your written waiver. The Court of Appeals, at least from my perspective, has said, where you purport to make it sound as though the waiver of appeal will include post-conviction remedies, 440s, habeas. The court has frowned on that considerably, and yet your office's written waiver says, I am giving up the right to have any court review my case afterwards. Don't you think that that could include post-conviction remedies?
Well, I think if Your Honor is asking, could that language be more precise, then I would agree. It can be. I guess I'm arguing here is
It's
that.
one understanding, right, Mr. Hillary? I'm sorry to cut you off.
Oh, no, that's perfectly a valid point, Judge. And I think that if the rule were that the language had to achieve a certain distinctive level of precision, then arguably this language falls somewhat short of that. But I think what the courts are saying is that when you look at the waiver, the colloquy of the court, any accompanying written documents in totality, and then you look at the court's manner of addressing the defendant personally about their understanding of the issues and counsel's discussion with the defendant, whether or not that was fruitful. And the defendant says repeatedly, yes, 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 yes. And there's no other reason to doubt this defendant's intelligence and competence in the circumstances. That I think here in totality, these documents, or the document together with the oral colloquy, establish a sufficient basis of knowledge for the defendant to make an intelligent choice. If the court doesn't have any questions, let's move quickly to the consideration point, if the court wants to hear that briefly. I don't believe that the court should move on from consideration. I think that accords with justice here. The consideration, of course, was the concurrent sentences. That was a legitimate benefit to the defendant here. Thank you.
Thank you. Moving next on the calendar to number 323, People v. Peterson. Ms. Markarian?
Yes.
Good morning. We'll wait for, I think it's Ms. Healy's coming in. Ms. Healy, good morning. Can you hear us okay?
Good morning, Your Honors. I can.
And we can hear you as well.
Thank you.
Good morning. May it please the court, Krista Markarian from Legal Aid on behalf of Judicial Peterson. I will be addressing points 1 and 2 of my brief, and if time permits, point 4. Pursuant to point 1, Mr. Peterson's constitutional rights to confrontation were violated when the people read a portion of Griffin's statement into the record. I would note that in Hemphill v. New York, they strictly struck down the door opening principle, which was what was relied by the court and the people during trial. I would further note that the rule of completeness does not apply in this case.
Why doesn't it apply? It seems to be, just to let you know what you're getting into, it seems to be the perfect example. That is, defense counsel cross-examines and says to the officer, well, the witness didn't say that he had a gun, correct? Correct. And then the statement that the witness signed, as I recall, is, I saw the defendant in the back seat of my vehicle with something black in his hand. Doesn't that allow, shouldn't that be allowed to clarify or complete? And so that the jury is not left with the misimpression that that there was no evidence of a gun from this witness? So that's what I'm stuck on. It seems to me that this sort of fits it pretty well. Why doesn't it?
I don't believe so, Your Honor. At no point did defense counsel read a portion of that statement into the record, merely alluding to the statements. What the defense counsel was doing was teaching the officer on the different steps in investigation she took between the two main witnesses. Merely alluding to what was happening in the statements and not reading it whatsoever, I think is similar in Hemphill, where no statement was read into the record.
So in a way, your Hemphill-based argument, and I know you put a lot of time into it, and it's an interesting issue, but that's sort of beside the point. You're saying that even assuming rule of completeness, and Hemphill had nothing to do with that, as the court itself said, you're saying this doesn't fit the rule of completeness at all. So in a way, am I correct that under that argument, Hemphill is irrelevant?
I would say that it's not completely irrelevant because the Hemphill court did not address the rule of completeness because no portion of the statement was read into the record by defense counsel. And I would argue that that is similar here. that merely kind of alluding into those differences into the statement as what happened in this case is not an implicit waiver that the concurrence was suggesting.
You're not saying that Hemphill essentially eliminated under the federal rules of evidence, the rule of completeness, are you?
I'm not, Your Honor.
Because they've amended the FRE as to section 106 to actually expand the rule of completeness.
Right, Your Honor. I think it's where it's similar in this case is that in Hemphill, they didn't have to go down the route of the rule of completeness because defense counsel didn't read a portion into the record, which is what I think what happened here. I think merely asking about the statement but not reading it into the record, that doesn't open the door to the rule of completeness as well. And I think it then creates a slippery slope because it allows trial judges to determine whether or not a misleading impression has been made, which was also, but what that proposition was directly struck down in Hemphill.
It's an interesting issue. Would you mind taking us to your second point on suppression?
Yes, Your Honor. As to suppression, the police lacked reasonable suspicion and probable cause to stop the car in this case. In evaluating the dispatch calls that were made, this was an anonymous informant. And looking into People v. Van Every, that was a case where it was an anonymous informant as well. And prior to the stop, the police went to the scene, spoke to witnesses, gathered more information. That was not done here. The police had a very bare bones assertion of the stop. In fact, they cut off the dispatch call prior to gathering more information, and they did not corroborate the identities of the people in the car as well. And I would further note that once the police stopped the car, they did approach the vehicle with their guns drawn. And then as I will also just move on to point 4 as well, which is there was issues with a juror in this case. Although defense counsel didn't have an issue with the court discharging that juror, it is the court's duty to engage in a probing and tactful inquiry to determine whether or not a juror is grossly unqualified. In this case, the court did not do that. This juror had lied about speaking with the witness. The court did not confront them about that lie. They did not ask this juror whether they could render an impartial verdict. That was not happening in this case. And I would further note that they didn't even ask this juror, did you speak with other people about the conversations that you've had with this witness?
You realize that at least as I read the record, the obstacle you have there is no objections at all from defense counsel. If I read it correctly, it seems like defense counsel even agreed or consented to the juror being excused. But you would say we should reach it in the interest of justice for the factors you've outlined in your brief?
I would, Your Honor, and I would also say it is the court's burden to make a record of discharging that juror. But if there are no further questions, I will rest on my brief. Thank you.
Ms. Healy, good morning.
Good morning, Your Honors. May it please the court, Harmony Healy on behalf of the people. With respect to point 1 and the concerns that were brought up regarding Hemphill and the confrontation clause, I think that it's a mischaracterization of, first of all, the record as it stands. I think that just because she didn't pick up the statement and read it into evidence doesn't mean that she didn't enter a portion of the statement into evidence by asking the question that she did and eliciting the answer that she did. I believe that the content of the statement came out, and because the content of the statement came out under the rule of completeness, the rest of it should be admitted in. And this is distinguishable from Hemphill because Hemphill was discussing a plea colloquy when there wasn't even a reference to the plea colloquy or the contents of the plea colloquy. It was just a third-party culpability defense that was raised in opening statement that the prosecution said had a tendency to potentially mislead the jury into whether or not the third-party culpability scenario had any merit. That's not what happened here. A content portion of the statement was entered into evidence, and then under the rule of completeness, it had to be clarified.
And Ms. Healy, as I read the record, the context of the questioning at the time seemed to be, well, you spoke to Sumler and you told Sumler what Griffin said, but you didn't tell Griffin what Sumler said, but you did take a statement, and then you said she might have to go to jail if she doesn't give a statement. So the whole concept of a statement, as I read the record, preceded this question was, and she didn't say anything about a gun. So it wasn't just she didn't say anything about a gun. As I understand the context, it was in the context of asking the officer about the conversation or the statement given by Griffin. Am I close?
Yes, I think it was in that context, it was along those lines, but the actual, what the impression was before the jury was, and you never saw him with a gun, or she never indicated that she saw him with a gun. That's introducing a content portion of her statement, which then there was an obligation to go in and correct with the rest of it. Because otherwise the jury would be left to think that there was no corroboration and that there were no differences or similarities between Sumler's testimony and Griffin's statement. And I think in her brief, defense counsel indicates that the trial court didn't rule under the concept of the rule of completeness. I think that what they said, though, was that a portion of the statement was introduced. And so while they didn't actually say the words rule of completeness, that was the theory behind it. So I think that you can reach that.
And it looks to me, if I read it correctly, that the court referred to Melendez from the Court of Appeals as well as to the Richardson section, albeit from a prior edition. But all of those relate to the rule of completeness, as I understood it.
That's correct, Your Honor. And this court has, since the ruling in Hemphill, had occasion to rule on the rule of completeness, and you have upheld it as well. It was a little bit different under, I think it was Martinez, and it was portions of the grand jury testimony, but it's still somebody referring to a portion, the content-based portion of somebody's statement, and then having to bring out the rest of it to clarify. And I don't think that she brought out any more of the statement than was necessary. She only brought out the portion of the statement that was necessary to clarify what was brought out on cross-examination.
Why don't you take us to the suppression point, please?
With respect to the reasonable suspicion and the 911 caller, in this case, I don't think that he was truly an unidentified 911 caller. And I think that there are a lot of ways that you can use to indicate he has the self-identifying factors that he gave. He indicated where he was standing across from Bacchus on the corner of Franklin and Chippewa, that he had seen the incident unfold as he saw the gun being pulled. He's giving contemporaneous description of the vehicle as they're pulling away, as well as a description of the occupants. And within minutes, seconds even, the officers pull around the corner and see exactly the make and model of the vehicle, exactly where this 911 caller said that it would be, and the occupants are exactly match the description. And it's not necessarily a common scenario where you see a female driver with another person sitting behind them in the back seat without anybody sitting in the driver's side passenger seat. So I think the description is pretty it's pretty clear. And he also, at the end of the call, he indicates that he's working as a doorman for Detour nightclub. So I think that he gave self-identifying information, and it's in line with this court's holdings under reasonable suspicion.
And do you see any reason for our court to reach the unpreserved issue vis-a-vis the juror issue?
I do not, Your Honor. I think that it wasn't preserved, that was actually consented to by defense counsel. But I think that the court always has the ability to discharge a juror prior to, obviously, them deliberating. When, particularly in this case where they have proof that this juror has not been truthful. So I don't think that there was an obligation under that when it got to that point when they had proof that the juror was not being truthful with them. Then that person can't possibly be a juror that you want to rely upon. And I think that's why defense counsel consented to the removal.
All right, Counselor, thank you very much.
Thank you.
.324 is submitted, 325 is submitted. That should lead us to 326, the matter of Albert S.
Good morning, Your Honor. Joseph Jarzembek here.
Mr. Jarzembek, good morning to you, sir.
Good morning.
Thank you very much for making yourself available today.
Yeah, I apologize. I got
You did nothing wrong. Thank you for making the trek up.
That's okay.
We're all set. Go ahead.
May it please the court. Joseph Jarzembek for my client, Cheryl Zonneville, who is here this morning on this appeal on a termination of parental rights petition that was brought against her, as well as the co-respondent, Mr. Slager. This is such a sad case, Your Honor. As you read the record, my client actually had 4 children. The oldest child, Sarah, died in foster care. The middle children, Albert and Stacy are the children that are the subject of this appeal and of the TPR. And to add irony to this, there was another child, Jacob.
We
who-
typically try not to use the names.
Hmm?
We typically try not to use the
Oh, I'm
names.
sorry.
It's okay.
I apologize. The youngest child
Thank you.
was also, believe it or not, the subject of a mental illness TPR that was dismissed by a different family court judge recently. It's not in the record, but I think it should be noted to the court that there was some inconsistency in terms of the family court, in terms of different judges as to a mental illness adjudication. It's our belief that on the basis of the testimony, because this was basically a battle of expert witnesses in this case, primarily Dr. Nathanson for the county and Dr. Keller, who testified for my client and also for the co-respondent. And we feel, or I feel strongly, that the department did not sustain the burden of proof as to my client's mental illness. There are arguments here. My client has a GED. Her IQ is 82. She has some type of a disability, but that doesn't make her incompetent to necessarily raise children. My client complied with the Department of Social Services. She availed herself of numerous services. She regularly visited the children. She didn't have any issues where I believe the co-respondent had some significant issues with the county. I think that in this case, strongly believe that the department did not sustain the burden. And I think that's also clear by the fact that there was another petition involving a younger child that they didn't sustain their burden on the basis of mental illness. And so in light of that inconsistency as well, I believe that the court should reverse the underlying decision.
You really want us to scour the record, analyze the expert testimony and take a look for ourselves.
Yes, I
Really what
would
we need
defer
to
to the
do.
court for
Okay.
that, obviously. And I think that it's clear from the record that it would show that that they didn't satisfy the quantum level of proof to sustain on this case. And I'll rest on my brief in terms of the other arguments.
Thank you, Counsel.
Thank you very much, Your Honor, for your time and your patience.
Mr. Greenberg, good morning to you, sir.
Good morning, Your Honors. How are you? I'm arguing on behalf of Albert S., who is the father of the child, and I'm taking maybe a slightly narrower approach than Mr. Dorzenbeck said. I think the record is clear that my client has some kind of mental disability, because I think, he argued it with his motions with the American Disabilities Act, and I think to assume, so I will assume for the sake of the argument that he has a disability, and that the real crux of the problem of my argument then is whether he's capable of parenting for the child of the two children that are subject to this appeal. And I also point out that having a disability per se does not render him incapable of caring for the two children, the two surviving children. There was testimony that by his own testimony, the testimony of Dr. Keller, who testified on his behalf, that he does own a house, he does have an income, that there was nothing in the record that really shows that he can't.
You're really focused on the second prong, as I understand, and what addressing. That's where I read your brief, was really focusing on that, about the ability to care for the children in the foreseeable future. And you, as I understand it, you're relying on the expert testimony as well, like your co-counsel there, right?
Well, we're relying on Dr. Keller testified that he is capable of the caring for the children. You have Albert's own testimony. And that the other thing, there was also the inconsistencies of the experts from the other side should also be taken into consideration as well. I mean,
You are asking us to believe Dr. Keller's testimony more than we believe the testimony of the two witnesses that testify on behalf of the,
well, Dr. Nathanson and Dr. Namaste.
right, so,
Yes.
okay, so it's who we believe, it's whose testimony is more clear, more believable, rings truer. Is that what you're asking us to find Dr. Keller's testimony to do that?
Well, I think you combine Dr. Keller's testimony with Albert's testimony. That's why, I mean, we can bring in, like, we're the way I studied criminal law with Dr. Ewing at UB, when we studied People versus Hinckley. And he pointed out, you can bring in a psychiatrist and analyze anybody for 6 months and discover something.
Okay, so then maybe
You know,
there's a judge there, though, that sat and listened to all of this
Right.
and sort of made those evaluations. And you're asking us to, substitute our judgment for that judge who saw and heard the testimony? That's what you're asking us to do?
Well, I mean, that would be part of the appellate review, that you do have a right to submit yourself as the 13th juror. If this was a juror, obviously there was no jury in the family court. But you are free to, case law, as I said yesterday, is legion for the proposition that you accord the trial judge a great deal of discretion when analyzing. Because as Justice Green used to say, it's easy to Monday morning quarterback the trials. But it's not, an unlimited amount. So, you are free to make your own determination, to discover your own facts based on the record. So,
Thank you.
but I guess maybe to summarize your comment, Justice Bannister, is that yes, we would like to see a reversal. We would like to see Albert's parental rights restored over the children, because his testimony in combination with Dr. Keller's testimony demonstrates that he is capable of caring for them.
Okay, thank you.
You're welcome.
Counselor, thank you very much. We'll give it a good look.
Oh, thank you.
The next one, 327, is largely submitted, but I believe we have the AFC participating by video. Good morning, Counselor. Can you hear us okay?
Yes, I can.
Very good. We can hear you, and you're the AFC in this situation, correct?
I am, Your Honor. I'm Roxana Herod of the Legal Aid Bureau of Buffalo on behalf of the children, Mia, Benjamin, and Lorenzo. Today, given that the other parties have submitted, I would rest on my brief asking the court to uphold the decision of family court, but I am available and open to any questions the court may have about how the children are doing.
Counselor, I think I'm looking at the bench. No questions. I think we're all set. We appreciate you making yourself available very much.
Thank you so much.
Calling next 329, which is Shakira M. is Chad Stretmatter, I believe, et al. And the appellant is here in person, as I see. And then I think the opposition is by video. There we go. Counselor, good morning. The one, Ms. Rosen, can you hear us okay?
I can. Can you hear me, Judge?
We can. We're going to start the argument. Thank you very much.
Thank you.
Counselor.
Good morning, Your Honors. May it please the court, Mark Bachman, on behalf of the appellant, Dr. George Albert. As the court is aware, our position here is that the lower court erred in denying Dr. Albert's motion for summary judgment.
You argue in your brief, as I understand it, that you carry the burden on both elements, as we call it, on negligence and proximate cause. And then the question that we would say is that the plaintiff did not carry their burden with respect to establishing a tribal question material fact. And that's the obvious construct we have here. With respect to establishing judgment as a matter of law, here we have competing experts. It looks to me like the Supreme Court essentially did the battle of the experts analysis of it. So why is that not correct?
That's a good question, Your Honor. And here we don't have a battle of the expert, respectfully. And that's because we don't have equally grounded opinions. As Dr. Bufano, our expert neonatologist, and Dr. Albert, during his deposition testimony, explained, this is a situation where we have a protocol at Women and Children's Hospital back in 2014 where they have a strict protocol.
This was at Sisters, correct?
Where the events happened was at Sisters, Your Honor, but where the baby would have been potentially transferred for the treatment that they're arguing for at Women and Children's Hospital, now O'Shea's Hospital, of course. And at that time, there was a strict protocol, and it required these criterias, and it took into consideration the overall clinical picture. But as in real time, we're sitting here and we're looking at it in retrospect view, you can sit here and say, okay, maybe they should have transferred him, maybe not, but you have to look at it in that time period. And we have two doctors saying that these were the criteria, they had to meet these criteria, and both of them, especially Dr. Albert, who practiced at Sisters and was familiar with that protocol, said Women and Children's Hospital would not have accepted him for cooling therapy. And you have the plaintiff's expert who's
I
saying,
don't know if he said exactly that, but your expert says that there is a very strict, narrow protocol that the child has to meet within the first 6 hours post-birth. And only if the child meets that strict protocol, would you then do the cooling therapy. And of course, the cooling therapy couldn't be done at Sisters. It could only be done at Children's, hence the issue with respect to Children's. I get that. My question, I think, Counselor, is, would you agree that the record reflects that promptly upon being transferred to Children's, on the day upon receipt of this baby, that the baby was diagnosed, and I'm going to call it HIE, to spare everybody my pronunciation of it, but it's hypoischemic encephalopathy. I think I'm close. And do I have it correct that in fact, the baby was almost immediately diagnosed with HIE upon arrival at Children's?
that is correct, Your Honor, but that is 5 days later after various interventions, various treatments, various different situations with the baby. Baby had seizures. It had the situation is different. So if you're looking at
HIE, forgive me if I've got, I just want to make sure I've got understand the issue right. But HIE is a birth injury, right?
it can be, but it's more related to an ischemic injury. So
Which occurs during the birthing process, for example, through the deprivation of oxygen and the excess of carbon dioxide, which can impede the ability to have the respiration, which the baby wasn't having. So the question really is, were there sufficient signs and symptoms of HIE to require the transfer to Children's? Your expert says no, because here's this strict protocol. The plaintiff's expert says yes, because it's more of a holistic assessment of the factors, including, as I understand it, the decelerations of the heart rate during the birthing process, which occurred over 2 days, as well as the acidosis of the baby that he or she was diagnosed with afterwards. And acidosis, I think, also is a lack of oxygen and excess of carbon dioxide. So, I mean, isn't this for a jury to decide as to whether or not there are sufficient signs and symptoms within the first 6 hours post-birth? Since we now know hindsight that HIE occurred, shouldn't we have a trial as to whether or not somebody should have recognized those severe HIE symptoms during that process? And Counselor, you have to forgive me, that was a really long question.
it was. That's all right. And I think I got the gist of
And I
it.
couldn't do it again, nor does anyone want me to. But do your best to address, why wouldn't this be a jury question? It's really the top question on my mind.
Yeah, and I think that goes to the heart of it, and it's really a question of severity and basing it on severity. And as our expert said, you're going to cool a baby in 2014 if the baby displays moderate to severe HIE. And at that time, we had a cord blood gas levels that did not show that. We had improving neurologic function with all the interventions, including normal saline, the sodium bicarbonate that improved the metabolic acidosis. And as we see in his testimony and in the record, the vent support was reduced because the baby was able to breathe. So the real question is, in that 2 hours, did that baby display a severe, if we're going to consider the baby having HIE from the moment it was born, did that baby?
Just to clarify, we know the baby ended up with severe HIE.
We do.
But the question is, would the signs and symptoms of those during that first 6 hours been evident enough such that it would be negligence not to have recognized it and applied cooling therapy?
That's correct. And I would go a step further and say, yes, it's within those 6 hours, but it's the first 2 hours, because that's the only time period he had the opportunity to even make that decision or recommendation to transfer the baby. And within those 2 hours, there's no evidence that the baby had moderate to severe HIE. And
is there anything in the record, the notes of your client, or by the nurses who may have been speaking to your client during the process, anything in the medical record where it's recorded that among the differential diagnoses was HIE by your client during that 6 hours? I didn't find it, but if it's there, I'd like you to point it out.
Well, that's the thing. There is no documentation of HIE, but there is documentation of perinatal depression, respiratory depression, and those sort of conditions can lead to HIE. So he says in his testimony, as soon as I came in to see this baby, I was concerned for risk of HIE. He's a
You
But is
know,
that concern noted anywhere in the record by your client or anyone that was cooperating with your client to treat this baby? I couldn't find it. And that's, how can you claim later that something happened? Because you may know, I did the medical malpractice part for a number of years, and I would hear from defense lawyers that say, if it's not in the record, it didn't happen.
Yeah, and respectfully, I would disagree because that's not the process of a differential diagnosis. You're not going to write down every single diagnosis you have in your mind. And
I actually thought that was the point of a differential diagnosis, where you had bullet points and you write everything that's on your mind.
no, I think that would be, especially in a situation where everything's in an ED, or in this situation, you're not going to write down every thought. You're going to continue to analyze each data point that comes in, and you lower the differential based on what's coming in. And if you have something like, okay, you have metabolic acidosis in an hour on the first arterial blood gas, right? Okay, that's concerning. So what do? You give the treatment that's going to correct that. And if it doesn't work, okay, maybe that brings your differential of HIE up more. But they gave them the only treatment to correct the metabolic acidosis, and it worked. You can see that as the night went on after Dr. Elber left, his pH and his base excess went down to the normal range, the range of what the core pH was when the infant was born. And I think that is an important part of it. And I think Dr. Elber in real time, and I think Dr. Bafano during interaffirmation, they understand that you're not going to regardless of how strict it was in 2014, you're not going to not send an infant for cooling therapy if they require it just because the core pH and the base excess don't reach it. I think that is important. And as Dr. Albert says, those are two major pivotal points of determining whether a baby is there for cooling or needs cooling. But he didn't stop there. He went on, he looked at the baby, he ran tests, he ordered treatments, and he responded to the baby's reaction to everything. And, you know, for what it's worth, Dr. Riley, after the fact, after Dr. Albert signed out, continued the same care line of treatment, and the baby continued to progress. So I think that's the issue there, and why there's no battle of the experts. And to go back, we have no foundation from the plaintiff's expert that they're familiar with the protocol at Women and Children Hospital. When you have Dr. Albert, who is—
So they had to be familiar with the protocol at that particular hospital or with the standard of care within the profession at that time. I think you're free at trial to argue a locality rule, perhaps, but I don't really see any evidence of a locality rule. You're arguing more of a facility rule, and I don't know that that's supported in the case law. But you've made a lot of good points in your brief, and we appreciate your going back and forth in the argument here today. Do you have anything further with respect to the battle of the experts or the other issues that you've raised in your brief?
I don't, Your Honor. If the court has any other questions, I'd be happy to answer them.
Thank you very much, counsel.
Thank you, Your Honor.
Ms. Rosen, that means you're up on behalf of the respondent.
All right, good morning, Your Honors. Jillian Rosen for the plaintiff respondent. I would like to just touch upon first, before I go into my argument, is that my adversary is claiming that that Dr. Albert comported with the standard, with the protocols of the hospital, but there's no protocol submitted. That's the first part. No, they didn't submit any protocols from the hospital. But even if they did, and even if the protocol says you just consider the APGAR at 10 minutes and you just consider the cord gas, even if that's what the hospital says, the hospital protocols does not mean that that meets the standard of care, which is what you alluded to in your question to my adversary. Our position is that even if it said that, our expert who goes toe to toe under the case law that's required in your department, in addition, states that he's familiar with the standard of care, and that actually the standard of care was not to just myopically look at the APGAR score and at the cord gas, is to look at it in a context of a clinical picture, in addition to the fact that our expert opined that the APGAR shows the neonatal depression, and the blood gas, it was not just the cord gas that you get from the umbilical cord. Our expert opined that the arterial blood gas, okay, within an hour of his birth showed minus 14.1. And that when you have an infant that has a base excess of 10 to 16, it's metabolic acidosis, which I think Ms. Bafino admits that there was metabolic acidosis within the first hour. So you have the APGAR. If you look at the APGAR and the cord gas, our expert says it still meets, he should have been a presumed HIE. Then our expert also discusses the abnormal neurological exam, the fact that he had hypotonia, respiratory distress. He was on a ventilator. He had to be intubated. He was consistently on a ventilator, not only within the first 6 hours, but within the first 3 days before he was transferred to Buffalo Hospital, he was maintained on a ventilator consistently. So we have the ventilator, we have the fact that his neurological exam is grossly abnormal, and you also have the fact that he had to be resuscitated and on the ventilator with beyond the 10 minutes of life, which is another standard that our expert says should be looked at in totality, in addition to the fact that he had a very, very rocky labor and delivery with variable and late decelerations and
There was a nuchal cord too, wasn't there, counsel?
I'm sorry?
Wasn't there, and I'm probably mispronouncing it again, there was a nuchal cord that issue as well, right? So there's deprivation of oxygen during the birthing process is at least some evidence in the record.
Right, that's the hypoxia that puts him in a presumed HIE, which was when he was born. The APGARs were 3 and 3, which is just devastating. And I'd like to point out something that the court brought up, which I think establishes the propriety of the trial court's order denying summary judgment. You have the hospital receiving JM on August 16th, and this is what it says. Baby with perinatal depression, low APGARs 336, metabolic acidosis at 1 hour of life, hypotonia, and ventilator dependence at referral hospital equals criteria for moderate to severe HIE in first hour of life. I mean, if this is not standing alone should deny summary judgment, I don't know what else should. And the truth is that, oh, I'm sorry, am I getting a question? Okay.
You're fine.
What our expert emphasizes that when the totality of the value of the evaluation suggests HIE, which obviously it did. He doesn't go from non-HIE in the first 6 hours and all of a sudden 4 days later and 5 days later, after constant ventilation, constant documentation of a depressed neurological state, and then all of a sudden he's HIE. My expert doesn't even have to say that. I just think that just is common sense. In any event,
as I read your brief, and I don't mean to steal your thunder here at all, but really what you're saying is that this case at this stage on summary judgment comes down to a debate about whether there was sufficient risk of HIE within the first 6 hours after birth. And if so, that it would require cooling therapy. I mean, the briefs were great. The issues were well outlined, but your essential point is what Supreme Court says. There's a battle of the experts about that debate. The holistic versus the particular.
Sorry, Your Honor.
I did that to you. I did that to you. Go ahead. I asked you a question. I should let you answer.
No, sure. That is our point. The first 6 hours and a defendant's expert, Dr. DeFino, actually, or I think it's Dr. DeFino or Dr. Albert, regardless, the defendant admits that the standard of care in 2014 is to administer the cooling therapy within the first 6 hours of life. They actually concede that. Here, that is our claim, that within the first 6 hours, surely, even in the first 2 hours, he should have been presumed HIE. All of the factors that we went through before establish that. Right. And that he should have been treated as such and transferred. And with regard to causation, which I find really interesting, is that the defendant takes the position, oh, well, he had a depressed neurological state anyway. It wouldn't have made a difference. I believe that's what DeFino's saying. You would say
this is a classic, counsel, you would say this is a classic loss of chance case.
Correct.
Deprived of a substantial possibility of a better outcome.
Correct, because plaintiff's expert actually explains in his or her very detailed affidavit, is that this is an evolving process, and also time is of the essence, which makes sense that you have to administer in the first 6 hours, and the brain, the whole point of it is to slow the brain damage, the cells that are continuing to spread and die. That's the purpose of the cooling therapy. So to say that, well, he's already in a depressed state at birth, right? He should have been presumed from the get-go, and he should have been managed and treated as a presumed HIE patient transferred for cooling therapy. That
And
is
you
our
would say, you would say on this motion, it's not your burden to prove a deprivation of the loss of a better outcome, just to raise a triable question of fact on that issue of causation.
That's correct. That's what the law, case law requires with regard to loss of chance and causation in opposing summary judgment.
Thank you.
Yes, Your Honor. If Your Honors have no further question, I'll rest on my brief.
Thank you very much, Counselor. We're all set.
Thank you. Thank you very much. Have a good day.
Moving next on the calendar to number 330, Connors and Ferris LLP versus Brown Chiari LLP. Both counsel from my notes here indicate to be present, and there they are.
Morning.
Well, good morning, sir.
Nice to see everyone. Pleasure to be here. If it's not in the record, it didn't happen. I just heard. And I would submit that that's exactly the situation in this case. The uncontroverted documentary evidence establishes that Connors and Ferris made a referral of Mr. James Forster's third-party claim to Brown Chiari, and that referral resulted in an engagement that resulted in a resolution of a substantial labor law claim, and that Connors and Ferris, pursuant to an agreement, was entitled to a fee of 1/3 of the attorney's fee earned in that matter.
And Counselor, that's not in dispute, that standing agreement. There's no issue about
The standing agreement is not in dispute.
The dispute is whether this particular client fit within that standing agreement.
That's correct. And nor is in dispute the course of conduct of the parties. And it's really important here to understand that because that goes to the very heart of whether or not there was a referral made in this case. The course and conduct of the parties was that Connors and Ferris, when they had a potential referral, would write a letter to Brown Chiari, send that letter, and in that letter, they would give instructions. Here's the client's name and number, and we've counseled the client to call you, but you may want to call him as well. That's exactly what happened in this case. December 31, 2013, Connors and Ferris sends a letter to Brown Chiari. Mr. Forster is being referred to you. We've counseled him to call you. Here's his number. You may want to call him. January 3rd, which is a Friday, Mr. Forster calls Brown Chiari. Brown Chiari engages Mr. Forster on that day. He signs a retainer that is not only signed by Mr. Forster, but is also signed by Mr. Shinta on behalf of Brown Chiari. And in that retainer, it specifically says, client acknowledges that this case was referred by Greg Connors and Ferris, and that Mr. Connors assumes joint responsibility for the handling of this matter. That was January 3rd, a Friday. Monday, January 4th, Saturday, Connors and Ferris enters into their Needles case management system, their intake, that Connors and Ferris is the referring attorney on this case. Okay. Now, January 6th, Monday, Sam Capizzi, equity partner at Brown Chiari, sends an email to Greg Connors. Dear Greg, thank you for sending this one in. We've been engaged. Okay. The case proceeds, they litigate the case, they ultimately result in a $2.4 million settlement, and they decline to pay any fees to Connors and Ferris. And the position is that the referral didn't come from Connors and Ferris. It came from some unknown individual at ECMC, and that's what Mr. Forster, who is now deceased, has told us. But we have no way to establish that.
Now, Counselor, I understand the timeline. We've got the timeline here, but there's nothing in the record that Connors and Ferris did any work on this file, right? I mean, even though the retainer agreement says that they assume the joint responsibility for this client's care or this client's project, there's nothing that the firm did to advance the client's interests. Is that correct?
Well, I would respectfully disagree. They were sharing medical records. They were communicating regarding the status of the workers' compensation. I presume, although I don't believe it's in the record, but as they would assist with the resolution of the workers' compensation lien. But they worked closely together. In fact, in the record.
But I guess the point though is that's sort of irrelevant because that's not what the agreement was between the law firms. The law firms really had this standing agreement, which isn't a dispute, that if a referral is made, and a 1/3 of the third fee is due and owing to your office.
That's correct. And they don't dispute the fact that if the referral came from Connors and Ferris, that Connors and Ferris was entitled to the fee.
Right.
Their position is merely that it didn't. And in opposition to the motion, there was nothing submitted in admissible form to shift the burden or to raise a tribal issue of fact. The only evidence submitted in opposition to the motion and to the mountain of documentary evidence is Mr. Shinta's affidavit, wherein he says, which I believe to be inadmissible hearsay, Mr. Forrester, who is now deceased, told me that somebody else told him to call us. And his wife, who wasn't his wife at the time, also told us that Mr. Forrester wasn't referred to us by Connors and Ferris, but we can't locate her, so we have no way of verifying any of that. And so, but that's all hearsay. It's not admissible. It's not sufficient to create a tribal issue of fact. And even if it were, the documentary evidence is just so overwhelming here. And when Mr. Capizzi sends that email on January 6th, he is acknowledging the referral. There is no reason for Connors and Ferris to believe it doesn't have an agreement on this case. There's no communication for years about this case from Connors and from Brown Chiari saying, hey, we made a mistake here. This case never came from you. Only after the case was settled, that this came to light. And there was nothing that Connors and Ferris could have done along the way because they had no reason to think that Connors Brown Chiari was taking this position.
Just so that I have the legal construct correct, and it's probably stating the obvious, but you're essentially seeking summary judgment on breach of an oral contract cause of action, saying that there's no dispute there was such an oral contract, there's no dispute that your client performed under it, that there was a breach, and that the damages are easily calculable. That seems to be in terms of just giving it the legal construct, Mr. Elbow, that's your argument. I'm not trying to steal away from anything else you had to say, but I'm just trying to get it into simple terms for me.
In simple terms, Judge, I think that's it. And I think all of the documentary evidence establishes that. And I think it's worth pointing out that there is a procedure in the rules of professional conduct as to how these fee sharing arrangements are supposed to be handled. And this was handled according to those standards, with the referring attorney being placed on the engagement letter, the client being notified. And let's remember that engagement or that retainer agreement was prepared by Brown Chiari. They prepared it. They inserted Mr. Connor's name into it. The client signed it, and they also signed it, acknowledging that. And so to now say all of this is just a giant mistake. We don't know how all of this slipped through our system for 4 years. The retainer was a mistake. The email from Mr. Capizzi was a mistake. The data entry into our needle system, that was a mistake. We promise you this didn't come from Connors and Ferris. It came from somebody, but we don't know who.
And all that, from your perspective, your client's perspective, is beside the point.
It's all beside the point because we've established our burden, and when it's shifted to them to raise a tribal issue of fact, they haven't and they can't.
Thank you, Counselor.
Thank you.
Please, the court, Michael Senta for respondent. I think what's important here is number one, as you touched, the burden is theirs to establish that there was a fee agreement in this case. Their own papers state that it has to be as a result of a generation of a referral from Connors and Ferris. That has all been explained.
Counselor, let me jump right to Mr. Capizzi's email.
Yes.
And what do you make of this email where Mr. Capizzi explains that, and this is the email, thanks for sending this one in.
Yep.
We met with him and he got retained.
So my understanding of that, as in our papers, is that he doesn't understand or had no idea, and they were entitled to take his testimony. And we shall be as well. We're entitled to every favorable inference on that as well. But he didn't understand or know about the fact that on that Friday at 5 o'clock, I ran out the door to meet with this client. He didn't know about the communications that I had with the client that day. We also have communications that are in admissible form. I don't know where that comes from, that there's no admissible evidence. But on that day that I overheard the conversation and I took over the conversation with the client
Right,
that
so
day.
your position is you initiated the client conversations vis-a-vis your firm, but then how do you explain the retainer agreement that's got your signature on it?
Yes, now, so the retainer agreement,
But just so
Yes.
frame this, I mean, the retainer agreement says that the referring attorney is Mr. Connors. It's
correct.
got your signature on it.
Yes, it does. And I can tell
You
you,
weren't confused when you signed this, right?
when I went that day, as is in the record, there was no indication, I never saw that on the retainer agreement. I had talked to the client on the telephone. I had spoke to the client at their home. Whether that was auto-populated or placed on the retainer because they were the workers' compensation attorney, which they were. So to say that this came up later, they were the workers' compensation attorneys for 3 years on the case. Then it was confirmed that we had known for 3 years where that case came from. Then it's 5 years after the retainer that there's a lawsuit brought to state that they're the referring attorneys. And this was explained to them, and that's in the record. This was explained to them after that occurred.
Right, but you understand for there to be a question of fact, this retainer letter has to be impeached. This retainer letter, we have to find is ambiguous or a mistake or something like that, and as well as the email, right?
No, what has to be done here is they have to meet their burden of showing, just like the lower court said, that there is a retainer agreement. The terms of any agreement on this case are established here. Okay, and those aren't established. Those have been explained. Those have been brought to the court's attention in response to a motion for summary judgment, mind you. That those have been brought to the court's attention as to what had occurred and what had occurred for 3 years following this on a case that I personally know where it came from. The fact that there was a mistaken email by Mr. Capizzi, which is less than a memo hadn't even been written at the time as to what occurred, is not evidence. What the evidence, what his belief may have been is not before this court. What is before this court is what I know to be the understanding at the time, what I know the facts to have been, and what those facts were established 3 years later when the case was settled, and then explained to the Connors and Ferris firm. That was all explained, and it was confirmed. What we did was confirm where that case came from, even at the mediation of that case. No further questions. Thank you, Judge.
Thank you very much, Counsel. Okay, I think we're at 331, Owen versus Hurlbut, and 332. And Justice Del Conte is disqualified on both appeals. I think, counselors, we're gonna take these as separate appeals because there's a discrete issue on the first one on disqualification, as I understand it. So you'll kind of be getting up back and forth a couple times, all right? Just as opposed to combining it, I think it'll be at least easier for me to have you argue them one at a time. So I think we're ready for 331, which is the disqualification motion first, I think.
Absolutely, Your Honor. With respect to disqualification, the facts in this case, the undisputed facts, are astonishing. We've got 3 different grounds for disqualification.
1.7 advocate witness rule and 1.9 on the supplemental motion or something like that, I think, right?
Exactly right, Your Honor.
So that's current client, witness rule, and former client.
Yes, Your Honor. Yes, Your Honor.
Which one's your strongest?
Well, I think in the case of a concurrent client, I mean, we've got a law firm that was representing both sides of the V in this lawsuit. They were representing the plaintiff, which is ROM on a derivative action, the corporate entity whose interests are being furthered by the plaintiff. And they're also representing the defendants. We filed for disqualification in March. In April, Solano and Farrow was counsel of record for ROM, our client, before the USPTO in connection with 2 trademarks, the Hurlbut and Hurlbut Care Communities, both of which are relied upon by Mr. Hurlbut in connection with the operation of his nursing homes. At the same time, they file an application in April, which is a month after we moved for disqualification, on behalf of the defendants in this action before the USPTO, seeking to re-register those same trademarks to the defendants. So it was registered to our client, the plaintiff. They applied to re-register it. They're counsel for both parties before the USPTO. And what's really fascinating is that Polano and Farrow entered an appearance for Ram, our client, in the fall. And the only thing that they did after replacing Harder Seacrest as counsel of record before the USPTO is to allow those registrations to lapse so that they could be re-registered to the defendant. So I think the concurrent representation, they also represented Ram in multiple other proceedings that are in the record as well.
See, 1.7 of the current client issue seemed to be your primary focus. That's why I asked that initial question. I'm not suggesting that you're throwing the other two arguments under the bus, don't get me wrong. But that seemed to be the focus of your motion. It was your first point in any event.
Well, it was our first point. It was not the focus of the original motion because frankly, these events transpired after we filed the original motion, and we made the motion to supplement to include these facts, which are undisputed, by the way, and below the opposing side was allowed to provide a full submission in response to that. They didn't dispute the facts as they were set forth. Full opportunity, no prejudice. We never understood why the motion to supplement was denied, but I think, again, when you have undisputed facts of concurrent representation, it seems like a pretty clear case for disqualification. And as to the other two, I mean, we also have Rule 1.9, former representation. So in this case, we had Polano and Farrow representing Ram, the corporation, in connection with a series of transactions, mostly transpiring in 2019, but continuing through 2021. These are the very transactions that are challenged in this lawsuit, specifically the misappropriation of an entire business that was owned by the marital trust and moving those assets under an entity that was owned 100% by Mr. Hurlbut.
Just so I have it correct, Ms. Foss, just focusing on that chunk of facts, so to speak. That's really, for both appeals, is really the main driver in the litigation, right? That this about the raiding Rome, and that's the wrong phraseology, I'm sure. It's the best I could do.
Good alliteration.
Yeah, especially now that I think of it. Sorry. Raiding Rome. Okay, in any event, but ROHM, the corporation, really when the allegations, Mr. Hurlbut basically disabled that corporation, took all the assets and put it into HHC or whatever it is, something like that. That's sort of the focus on it. You're saying, wait a second, they were former lawyers for that, and now they are still, they're substantially related transactions. I'm kind of rambling a little bit, so help me out here. Am I close? And if not, let me know.
Absolutely, Your Honor. I mean, the firm orchestrated the very transactions that are challenged in the case as being for breach of fiduciary duty, and which, by the way, the lower court found was a breach of fiduciary duty as a matter of law. So you've got the firm involved in orchestrating and facilitating those very transactions that are challenged. The test under Rule 1.9 was the former representation substantially related to the current representation. And I think that this court's decision in matter of Greenberg in 1994 is really on point here. That case involved a cabinet company. There were a couple of shareholders, one of which was the controlling shareholder in charge of that corporation, transferred out the entire business of Madison Cabinet, moved it under an entity that he owned 100%, continued all the same contracts, transferred, basically just changed the name on the door, and moved it into his own entity. This court found that not only was that a breach of fiduciary duty as a matter of law, self-dealing, but that the law firm that was seeking to defend the corporate fiduciary against these charges needed to be disqualified. This was a reversal of the lower court's decision in that case because the firm itself had assisted the corporate fiduciary in facilitating those very transactions. And then, of course, we've got advocate witness rule as well, and we've put evidence into the record showing that when asked about these transactions, employees of the entity deferred to lawyers at the law firm.
The one thing that concerns me there is whether or not, whenever you try to put a lawyer on the stand, one of the first questions we're going to think about is who else could testify to that same stuff, so to speak. And I think the argument is, on the other side is Mr. Hurlbut can. In fact, you've already got his testimony that seems to indicate he's agreed as to what the facts were. So I'm not sure the lawyer witness thing is the strongest one you have, given that. Am I wrong?
I would put it as a 0.3 in terms of the three. I mean, I do think that there are advocate witness problems. And, another thing that this court can take into consideration here is the fact that under appellate division case law, where a lawyer facilitated a breach of fiduciary duty, participated in that, that those communications are not considered privileged. Under the crime fraud exception, where the law firm or a lawyer is involved in assisting, aiding and abetting a breach of fiduciary duty, those communications become discoverable.
Your client hasn't sued that law firm yet, correct?
Has not named it as a defendant. I would say that, litigation strategic choices, it's not named at this point, but that doesn't.
Statutes of limitations are coming and going perhaps in the interim.
Not entirely, Your Honor, because the asset.
That's a separate issue.
It is a separate issue. The decision has been made not to, this is a multi-front litigation already. We've got multiple different proceedings between the parties.
There are sort of figured that out.
Yes, there are strategic choices that have been made, but it doesn't erase the issues, and particularly with the malpractice liability that remains out there. There is no running statute of limitations on that under the continuous representation rule. So those same conflicts of interest still exist.
Thank you, Counsel.
Thank you.
Mr. Valentino, correct?
Good morning, Your Honor. Yes, Christian Valentino.
On the disqualification motion.
On the disqualification motion only right now, right? Yes, Your Honor. Thank you. May it please this honorable court, opposing counsel.
And I'm not sure you need to spend a lot on the lawyer advocate rule, but let's go to 1.7 and 1.9.
Yes, Your Honor.
In particular, please.
Obviously, this is an abuse of discretion standard. Judge Chacho certainly had all of the same facts before this court in front of him when he made that decision with respect to the Greenberg case, since it was cited by opposing counsel in her oral argument. Judge Chacho goes to great lengths to distinguish that case, and we agree with that analysis in terms of why Greenberg is distinguished. With respect to the various rules, I do want to caution or ask the court to take caution when reviewing some of the allegations in opposing counsel's briefs. She used the terms like orchestrate, the law firm orchestrates things. But when they utilize these terms in their legal briefings, please look for a cite, because a lot of the allegations are based upon pure speculation. For example, she referenced the fact that there were lawyers that were named in emails. Lawyers can't control if a client sends an email and throws a lawyer's name on it. So I do respectfully request that the court do, and I know the court will really look at these citations in terms of any time there's some type of allegation as to what Polano and Farrow may have done, because it is replete with speculative allegations using terms like orchestrate, things like that. With respect to Polano and Farrow's representation of various parties, again, Judge Chacho addressed this in his decision, as we did in our brief. With respect to the numerous lawsuits that Polano and Farrow is representing Ram in during this time frame, as stated in the brief, Ram was an administrative service provider for 13 nursing. I'm a plaintiff's lawyer as well. So what does a plaintiff's lawyer do when they sue somebody for negligence? They find any possible name of a company or associated company that might act as a defendant. So Ram routinely would get placed on these lawsuits as a defendant when somebody was suing one of the 13 nursing homes. As in the record and in the briefs, the insurance policies for these nursing homes name Ram as an additional insured, and it's for the benefit of the nursing homes to get rid of Ram as a defendant because the nursing homes are on the hook for bills, et cetera, right? So that's why Polano and Farrow was named as attorneys, not only for the nursing homes, but also for Ram on these litigated matters. And that's all in the brief. With respect to the trademark office, as Judge Chacho put it, the initial re-registration of Polano and Farrow as the attorney for Ram with regard to these two trademarks that only had to deal with the nursing homes. I mean, they were her blood. It has no value to anybody else. Polano and Farrow did register as the attorney who was going to handle that. And then as stated in the brief, it was subsequently discovered by the corporate group that was dealing with it. Wait a second, Bob Hurlbut resigned as the officer of ROM. We don't have any legal authority to do anything. And so it just went blank, like everyone just sat there. And it did, the trademark did expire. It was public record. Ms. Owen could have done something about it. The trustees of the marital trust could have done something about it. Nobody did anything about it. When it expired, Polano and Farrow was retained by Hurlbut or Hurlbut Health Consulting, I don't remember, to register that trademark. So these are, as the judge put it, these are ministerial issues. It doesn't rise to a level to get disqualified when you're looking at a client's right to retain an attorney of their choosing. Certainly, Judge Chasha did not abuse his discretion in denying the motion.
And that's where you started on abuse of discretion. You would say we should affirm based on the comprehensive decision of Judge. So we got to take a look at that.
And based on facts, yes, Your Honor. The other rule that they were looking at, so the advocate witness rule, you said, don't worry about that as much, right?
I mean, the other side argued it, so you know, it's
Yeah.
certainly fair to allow you to as well, but
I echo Your Honor's questions, which was.
I heard it's clearly a 0.3.
Yes, very good. For that 0.3, Your Honor, frankly, there are so many different people that they're going to question about these emails. Peter Abdallah, Harder, Seacrest, and Emery. Bob Hurlbut, as someone who wrote the emails. People at the Bonadio group. You know, people who are saying, "Oh, well, ask the lawyers." Well, you can, they can ask these people, and then if at that point in time, for some reason, there is a reason that they can justify to the court, and the court will issue an order directing attorneys to violate attorney-client privilege, and so be it. But it's not a basis for disqualification.
Thank you, Counselor.
Thank you.
Now, Ms. Voss, back to you on 332, which is, I think we have some standing issues there. Do I have that right, among others?
Standing was one of the arguments that was asserted by the other side. Yes, Your Honor. This is a summary judgment decision. There were 3 buckets of claims, and Judge Chacho ruled in our favor as to liability on 3 buckets of the claims, leaving the issue of damages, and then ruled and dismissed the 3rd bucket of claims on summary judgment. Standing, if Your Honor would like me to address the standing arguments, I can start there. Sure. So in this case, the claims in this suit are both derivative and individual. Christine Owen.
How are there individual claims here?
Well, actually, the one individual, yes, there are individual claims in terms of how she was impacted as a residual beneficiary of the trust. So the marital trust was set up during her mother's life, during both parties' mother's life. The mother was the income beneficiary entitled to all of the income generated by the trust. Upon the mother's death, the 2 children, Bob and Christine, were the 50-50 residual beneficiaries. So Christine Owen, in this case, she received 50% of the shares in ROM once they were distributed out of the marital trust. So currently the shares are owned 50-50, Bob and Christine. And the actions that are challenged in this lawsuit harmed her individually because what she received out of the trust was far less in value due to the misconduct of the corporate fiduciary, her brother. So those are the individual claims, but we have derivative claims as well. And also Christine is the executrix of her mother's estate, and she's pursuing claims on behalf of her mother based upon the failure to generate income during 2017, 2018, and a portion of 2019. For the derivative claims, there's really no question as to standing for that. It's Business Corporation Law 626 is what gives the right to bring a derivative action. And it allows that to be pursued by any holder of shares of the corporation or of a beneficial interest in such shares. And having a residual interest in shares through being a beneficiary of a trust does qualify for that. This court in the Sada case in 1989 said as follows, and I quote, "Plaintiff was the beneficiary of a trust holding stock in defendant corporation and thus was entitled to institute a shareholder derivative action." So that absolutely qualifies, but there's a separate basis as well, and that is under BCL 626B, which allows a shareholder to bring a derivative claim if he or she receives the shares devolving upon her by operation of law. And in this case, Tompkins Community Bank, which came in as the trustee of the marital trust, distributed the shares on a 50-50 basis to Christine and Bob.
happened, that devolved.
Correct, Your Honor, correct. So that's the gist of the argument on standing. As to the summary judgment, both parties are appealing. There's 3 buckets of claims. We have extensive briefing and extensive record. I by no means intend to cover everything, and I'm sure you don't want me to, that we set forth in the briefs. But I do think it helps to provide some highlights here, especially given the length of some of the submissions. Here we have a fiduciary, Mr. Hurlbut, who was supposed to generate income for his mother during her lifetime. He was the de facto trustee of the trust, and he was the president of ROM, which was owned by the marital trust. And his obligation was to generate income and also to protect the corporate assets for his sister, who was a residuary beneficiary. The time period that we're looking at here is 2017, 2018, and 2019.
Can I ask that, why is it seems that it started in 2019. That's when Zoen states that that's when the scheme began. So I don't know why you have 2017 and 2018.
And that's because of the other 2 buckets of claims. Certainly the scheme to misappropriate the entire business out of the trust to Hurlbut Health Consulting began in 2019. But what started earlier than that was the decision to deliberately run the corporation as a break-even enterprise. So Mr. Hurlbut had this company, which was a management company, serving the nursing homes and also serving some real estate enterprises. In 2016, Mr. Hurlbut became the 100% owner of the nursing homes. And so the nursing homes are 100% him and are customers of the management company, of which he is the president. And 2017, which is where we went back to on a statute of limitations, the trust is supposed to generate income for his mother. He deliberately, and he admits this in his affidavit, ran it as a break-even enterprises. He had his nursing homes pay only enough to make sure that ROM's expenses were covered and that there would be no income for his mother. And then in 2019, he used this as a justification to take the entire business out of the trust, saying, well, I can do whatever I like with this entity, and therefore I'm just going to take it, which deprives his sister of an interest in an asset that otherwise would have been valuable as a going concern. This is a management company that had 20 to 33 employees. And you have a record where it's admitted that he was making sure to set the fee arrangements in self-interested transactions with himself in order to divert the profits to his nursing homes, thereby benefiting himself. Again, 2019, when this scheme comes up to take the whole business out of the trust, he actually approached Harder Seacrest, which represented the marital trust at that time.
But we know the facts of this lawsuit, and they're complicated at times in this case, to be honest. But basically, ROM went into the marital trust in 2014. Do I have that right?
Yes, Your Honor.
And the record, as I understand it, reflects that, including at that point, if not before, ROM was always a break-even business.
Yes, Your Honor.
And your complaint is that in 2017, Mr. Hurlbut should have changed that MO, so to speak, to something that would have created greater profit for the marital trust.
Well, he should have done it as soon as the customers of the management company and management company were no longer under common interest and control. We go back to 2017 with starting the claims in this case, because we're looking at statute of limitations in terms of how far you can go back. But he was in charge that entire time period. Look, when the companies were under common ownership, under Bob Sr. Hurlbut, in that situation, he could structure it however he wanted.
So once they're arm's length, from your perspective, so to speak,
Should
they
have
had a
been.
heightened duty to pay Rom more compared to what did before. But if they have that kind of arm's length relationship, the counter comes in then too. That is, the arm's length relationship means we don't have to deal with Rom anymore. Goodbye. Why doesn't that argument hold?
Your Honor, because of the rule, the doctrine of entire fairness. In a normal situation, you've got a corporate fiduciary that's being challenged in terms of the decisions that that fiduciary is making for the corporation. The fiduciary is going to be protected by the business judgment rule. But the Court of Appeals has made clear, and it's been held over and over again, that rule does not protect a corporate fiduciary who's engaged in self-interested transactions. Here, there's no question that the transactions were self-interested, both in terms of the setting of the rates for what was being charged every year, the creation of service contracts and whether those service contracts built in any protections for the corporation at all, the misappropriation of the business and the setting of his own compensation. These are all self-interested transactions.
Do you think that sounds like a whole set of questions of fact?
No, Your Honor. And the reason that it's not, it might have been, had the other side put in evidence into the record to create tribal issues, but they didn't. I mean, under the Court of Appeals case law, this is the Appellate case in 1984. It talks about what's the standard for meeting the entire fairness doctrine. The corporate fiduciary who engages in a self-interested transaction takes on upon himself a higher duty and burden of proof to prove that the transactions were entirely fair to the corporation to whom he owes a fiduciary duty. And entire fairness requires.
You're saying he owed a fiduciary duty to Rom even after he bought out Christina Owens? I thought at that point your argument was resting on that they're now at arm's length.
No, Your Honor, because he remained president of Rom, running Rom. So he is running the management company in Rom, owing fiduciary duties to his mother and sister, while simultaneously operating the nursing homes and entering into contracts between.
And counsel, you should be mindful of your time. We've spent a fair amount of time on this. I don't want to cut off any important arguments, but just know that time is coming to an end.
I understand, Your Honor. So I'll do this quickly. To meet the burden under entire fairness, he's got to show both a fair process and a fair price for each of the challenged transactions. That was his burden, to put that evidence into the record. If it's not in the record, he doesn't meet that burden. And as a matter of law, he's liable, just like the Greenberg case, right? And here, the Court of Appeals says that looking at fair process requires looking at timing, structure, disclosure of information to independent directors and shareholders, how approvals were obtained, and similar matters. With respect to all of this, we put in a lot of evidence into the record that, far from trying to disclose these facts, Mr. Hurlbut went out of his way to try to hide what it was that he was doing, not disclose those facts, even in defiance of a court order from the surrogate's court.
And counsel, you've made all these points in your brief, correct?
Yes, Your Honor. So, and I do expect that there may be some arguments that come up on the other side. We've addressed standing. There's tax estoppel, the public health law, this apparent ratification argument. I think that those are sufficiently covered in the brief. So unless the court has questions on them.
Hearing none, we're all set. Thank you very much.
Thank you, Your Honor.
Mr. Valentino, back to you, sir.
Yes, thank you. I like the exercise. Your Honor, with respect to the standing issues, all I'm going to say is that here's why they're in there and why they're important. They make so many blanket allegations that they sort of group in with all of these potential plaintiffs, right? And where the money goes, if there's ever a recovery, and obviously we're denying liability on these things, but if there's ever a recovery, where the money actually would go to is actually very important, because if it goes into, if it's made by the estate, well, the money would ultimately be distributed different than if it went into the marital trust versus back to the corporate, back to Rom, or to Ms. Owen individually. So that's why the standing arguments have been vetted and addressed, and that's why they're in there. The 20th cause of action is a really good example. The 20th cause of action, it's an individual claim based upon that purchase and sale contract where Christine Owen voluntarily sold her minor interest. When I say minor, it's percentage. She was paid a handsome amount for her ownership interest in the nursing homes, right? That 20th cause of action has to, if you're going to give it any credence or merit, has to assume that the nursing homes that she just sold somehow have a continuing duty to Rom, to the marital trust, to the estate of Barbara. Those nursing homes are completely separate entities. And as a result, that's why these standing arguments have been made, because we need some guidance, I think, as to if there is a successful cause of action, where does the money actually go? So that's why they're there. And I just asked the courts to look at that. With respect to all of the other arguments, I feel as if the plaintiffs are coming in halfway through the story. They're ignoring the fact that I just talked about, which is the nursing homes have absolutely no duty to any of the plaintiffs. And they could terminate, whether or not Bob is running them, it's a separate legal entity. They not only had the right to terminate Ron, which they did, as briefed in our submissions, the law that highly regulates nursing homes essentially required them to. Frankly, that should have been done years ago, except I think Bob had the wherewithal to understand that the trustees, Mary and Jerry, Jerry Rotenberg and Mary Ross, they knew why ROM existed, the purpose of ROM, that it was never to make a profit. And not only was it run that way when Bob Sr. did it, after Bob Sr. Sold the property to Christine and to Bob. By the way, Bob and Christine got a significant benefit running it that way. Also, when the marital trust became ownership, again, the trustees were aware. This is all in the briefs. Barbara was aware. Christine was. It was always run as a break-even property, business, a proposition, and that was for the benefit, yes, of the nursing homes. It never had any other functions. All of the properties that are being referenced, that they were a property manager, those were all properties owned by Robert H. Hurlbut that passed when he died. So to take an advantage of something for so many years and then turn around and sue your brother for it, that's how we see what is occurring.
And Mr. Valentino, you've also filed a cross appeal, do I have that correct on this?
Yes, Your Honor. We filed, well, on this one, we filed the appeal, we appealed the court's decision, the orders that granted partial summary judgment on 3 issues, which I'm about to get to. The court gave partial summary judgment on Bob Hurlbut's salary. We all call him Bob, so it's not out of a lack of respect for my client. Everyone calls him Bob. But with respect to that motion, we put into the record the affidavit of Rob Nassau, who's been the accountant for every Hurlbut organization for decades. And he identified what Bob Hurlbut's salary was as president of ROM for years, while Christine was involved, while Barbara was involved, right? And then showed what his salary was after it became owned by the marital trust. The trustees were aware, everybody was aware as to what his salary was. And from our perspective, that raises a question of fact that a jury should consider, because you're actually comparing apples to apples. You're comparing his salary when Christine was involved versus when it was after involved. And that would create a question of fact that a jury should listen to if our client's not granted summary judgment on everything, but a jury should listen to and say, hey, it was reasonable. That salary was reasonable. And the other issue that we're appealing on is the fact that Judge Chacho says, well, I find it excessive, but I don't know what a reasonable salary is. So that contradiction in terms of what somebody is paid, in our mind says that there's a question of fact, because what if a jury came back that it was only $6,000 more than what he was paid for those years? So that's a question of fact, and we think that part of the decision in order should be reversed. The other issue was Judge Chacho in his decision said, well, all of the actual valuations over the years valued ROM anywhere between, I think it was 649,000 and about 789,000 or there's also in the record, Rob Nassau identified the fact that most of that valuation was due to a life insurance policy on Bob Hurlbut's life. And once you take that out, ROM had very little value because it was always a break-even proposition. So the court said, well, I don't know what the value of ROM is, but he must have underpaid because he only paid $85,000. Now, we can all clearly see what the $85,000 was paid for. And again, to us, that's a question of fact that should have precluded summary judgment on that issue. And then lastly, the court found that because of those other two issues and because of setting up of Hurlbut Health Consulting, that he was deemed to be a faithless servant and therefore he should disgorge his salary for those, I think it was 2 years. Again, it's our position that if there are question of facts on the other, you can't really call him the faithless servant yet until you determine exactly what was done. And from our perspective, not only did the nursing homes have the right to do what they did, once they terminated, the sequence of events happened and he did what he needed to do. Ron couldn't afford payroll. Ron couldn't do anything. And those are essentially our strongest arguments.
Counselors, thank you very much for your arguments and briefs.
Thank you.
We're all set. We'll take a close look. We have two cases here, number 334. It looks like three. I should know. Three, 333, 334, and 335. Bless you.
I'm sorry.
No, we feel bad for you. Bless you. So let's call Schwartz versus Schwartz. We ready? 333, 334, and 335.
Morning, Your Honors. Paul Vance, attorney for the appellant, Daniel Schwartz.
You'll be able to count heads up here on the bench, Mr. Vance. At least two of us were on the last ones.
Oh, were they?
We have some familiar, Justice Del Conte and I think we're both.
Well, I will try to limit my
We
arguments.
do have some familiarity. We're not trying to, constrict your argument too much, but we do have some familiarity on the panel as well as with the other members who are all taking a close look at the issues on these appeals.
Okay. So I will be as direct and brief as I can. Your Honor, with regard to the appeals, the first docket 0996, which involves an order of October 17th, 2023, that was filed by the then AFC for one of the children. And basically what it did is, without any attachments to the motion, without any.
Took the position, I don't have any of that stuff, and if I do have any of this stuff, I'll let you know and I'll destroy it and take care of it. He seemed to consent to the relief there. That case at least strikes me, Mr. Vance, without stealing your thunder too much, strikes me as not a big deal because your client essentially said, I don't have any of that and consented to the relief.
But Judge, we were forced into that position. If somebody says he sexually abused the daughter, we're not going to not answer that. We're going to come in and say we absolutely did not sexually abuse the daughter. That doesn't make what the court did here correct. What I'm saying is this man has been denied due process. He's been denied the ability to submit evidence that could be highly relevant, not prejudicial, and admissible in an effort to determine what is in the best interest of these children. Okay, and that is not only this order, but also the order of the 23rd. The order of October 23rd directed him, not the respondent, directed my client to do a separate affidavit, more detailed, saying that I didn't do this and I don't have this and I never recorded and yeah.
The purpose, as I understand of the more particularized affidavit, is to demonstrate, because I think in your opposition affidavit, your client says, I don't have this information. But he didn't say, I've never had it. I didn't have it in the past. And there was a separate issue of whether or not he had provided the children with electronic devices that would otherwise make the recording.
And again,
and that's all the court was asking for here.
Yeah.
And for some reason, despite your client's protests here, and in the last case that I've never had this information, he won't sign this affidavit that the court has asked him to sign.
Well, the point is he did. What he's appealing is the underlying order.
He didn't state. That's the issue, as I understand what the court below has said. He's not stating under oath that I've never had this information.
Again, Your Honor, it all goes, begs the question of whether or not the information he has is allowable, material, and relevant. It's almost like a prejudgment by the court that whatever this was in this affidavit that was submitted by the AFC, for whom I have the greatest respect, okay, is true. And it was not focused on an equal basis against the mother and the father. It was just focused on my client. No, we don't think that affidavit that he submitted is good enough. We want him to do another affidavit that says this, and this. The net effect of those affidavits, Your Honor, and the net effect of those orders are to deny my client due process. I mean, when we're talking about SBOC and Fedzowitzer, and we're talking about what's in the best interest of the children, and we're talking about the domestic relations law generally, we're talking about fearless and searching, discovery ability, our ability to see whatever we need to see. And that's being limited by the judge based on papers. I mean, all the judge had to say is, you know what, let's have a hearing. I wouldn't be sitting here. Let's have a hearing about this. Let me see.
Are you really taking the position here that your client's due process rights were violated because he was supposed to destroy communications from their lawyers?
No, because he's prevented from offering evidence that may be material and relevant. That's how his due process rights have been violated. Your Honor, going now to docket number, because I know it's late and you're tired. Frankly, I'm tired.
We gave you kind of a mini bar exam here today. We gave you a lot of different subject matters. Mr.
Yes, you did. And, after 40 years of doing nothing but divorcing people, Your Honor, I can say that this is only the second time I've appeared in this court, and most likely my last.
And I think you were going to the third appeal, right? You were taking us to the third appeal?
Yes, I'm taking you to the third one. And that has to do with the order precluding the in-camera review of documents and to quash the subpoena that we issued against counsel as it related to her affidavit that she put the issue of the trust at issue. She's the one who filed that motion and made statements about what counsel, she called her co-counsel, but Linda Greer has a separate retainer agreement that's attached. It's in the record. And what she attempts to do in an effort to get my client, quote, to pay the taxes on the trust, close quote, is she says, I've talked to Linda Greer, and Linda Greer says these trusts are this way. Okay. We have an expert, our expert totally disagrees. Okay. So all we wanted, because she put it at issue, we didn't raise it, she did. She's now waived the privilege, which is what she hid behind. She goes, oh, no, that's confidential communication. No. You put it out there. And the law is clear that once she puts it out there, even partway, she waives the privilege. And all we were looking for is, what did you rely on in coming to that conclusion? And obviously this is highly relevant to the children because it's the children's trust.
But wait,
Yes.
highly, we struggled with this the last time around. The only issue left in this matrimonial proceeding is getting this to trial for the court to make a custody determination.
Agreed.
And so we keep getting into trust and now blood types and everything else. And the court has been very clear. This matter is ready for trial.
I understand that. And they've given us a date in March of 2026 for that.
How is that possible?
I don't know.
I'm just thinking out loud. Okay.
Am I wrong about
Sorry.
that? So the bottom line is, Judge, the privilege has been waived. Okay. The material is relevant. It's relevant because it deals directly with the children's trusts. And one of the factors when we're considering, what's in the best interest of the children is what the children's economic situation is. And to suggest otherwise, that this has nothing to do with money, custody certainly has something to do with money in terms of the stability that the putative parent can afford the children, what their resources are, etc. So, and then I just wanted to respond to one thing that I'm anticipating. The issue was, and I believe, Your Honor, you correctly raised it, which is, well, if you complied, then you've waived. That's not the law, okay? If I don't comply, I subject him, first myself to malpractice, and him to a contempt citation. Or under 3126, a negative inference. You know, again, I use the extreme example. If he was accused of sexually molesting the children, we're not going to sit quietly, even though it's done improperly on a 3-paragraph affidavit signed by somebody with no corroborative evidence saying, I think this happened. You know, of course we're going to respond. You know, my client had no choice but to respond. But that does not hide the underlying problem, which is he's been precluded, and she has too, from offering evidence that may be highly relevant and material in the ultimate custody case, which hopefully be tried during my lifetime. Thank you, Your Honor.
Isn't there a preference for a custody case?
That's what I argued. Thank you.
Thank you. Mr. Coletta.
Thank you. May it please the court, Michael Coletta on behalf of the respondent, Melinda Schwartz. This case is, I think this court is aware, has a very long history. Issue was joined in June of 2019, nearly 6 years ago. As the court is aware, the appellant previously appealed a series of orders from the lower court, all of which were unanimously affirmed. Here we are again. I would submit.
You didn't have anything to do with asking the court to put this out a year, did you?
No.
Okay, so everybody here wants this case to be heard a lot sooner. And I just have to think, as you know, the custody issue being children being left in limbo, you know, that has got some urgency.
I don't disagree.
Okay, all right. I just want to make sure that I didn't step on any argument that you made, that you need all this time.
Oh, no.
And no, I
No,
didn't really think so.
Our client would like a trial ideally to have already happened, but here we are. And I would submit that these appeals are equally without merit. They are part of a pattern of vexatious litigation that is really serving only to prolong the case. Turning to the legal arguments, first with respect to the ordering the destruction of materials. None of the arguments being raised in this appeal were ever asserted in any papers or in oral argument before the lower court. In fact, to the contrary, it was represented to the lower court that the appellant had no objection at all to any of the relief that the AFC was seeking. Nor did the AFC for the other child, nor did the respondent. And so the court entered an order that was effectively on consent. And the case law holds that an order doesn't have to specify that it's entered on consent to be a consent order. If the record makes that clear, it's a consent order. And I don't know how you make the argument that when you represent to the court, I have no objection at all to any of the relief, that it's not an order on consent. Furthermore, it's academic because it's ordering the destruction of materials that apparently the appellant doesn't even have. So
we have a concept, as you know, called aggrievement. If you're not aggrieved by an order, we dismiss the appeal.
That's exactly right, Judge.
And that's the situation. What else do you have for us?
Sure. With regard to the more specific affidavit, I would just note that the legal standard is abuse of discretion. And I don't think that this court can find on the record that the lower court abused its discretion. We have a situation where there's a prior order in place explicitly saying that neither party is to have any discussions or communications with the children involving the litigation. We've got not one, but two AFCs raising concerns that there may be some interference in the attorney-client relationship. I think the lower court, having appointed these attorneys to represent the children, had an obligation to conduct an inquiry, and that's exactly what it did. It directed that the father submit a more detailed affidavit, more in line with the affidavit that the mother had submitted. The additional areas of inquiry were narrowly tailored, and the appellant complied with that and submitted an affidavit. As far as I know, or at least as far as I can tell from the record, there was no motion for a stay. So, for example, the appellant could have appealed that order and then moved for a stay so that he wouldn't have to actually submit the affidavit pending a determination of the appeal. That didn't happen. I suppose the appellant still reserves the right to bring a motion, in limine to preclude that affidavit from being used at trial. But those are his remedies. I don't see any abuse of discretion at all by the lower court. With respect to the subpoenas that were quashed,
those subpoenas were properly quashed on various different grounds. Number one, they're clearly on their face in the nature of discovery subpoenas. The subpoenas themselves reference CPLR 3120. The records are to be produced not to the courthouse, but to the law office of the appellant's attorney within 20 days. Coincidentally, that's the timeline under CPLR 3120. So if it walks like a duck and talks like a duck, it's probably a duck. And this was after a note of issue had been filed. So there can be no additional discovery. But beyond that, the subpoenas clearly seek material that is immune from disclosure. First, there's a subpoena served on the respondent, essentially asking for all of her written communication with Attorney Greer. And there is absolutely no dispute that Attorney Greer is her retained attorney. There's a signed.
Counsel alleged that there was a broken confidentiality by some discussion of, what went on between lawyer and client.
I understand that argument. So I think that goes more to the subpoena that was served on matrimonial counsel for her communications with Ms. Greer. And just by way of.
Who was that?
Elizabeth DePiro.
Oh, so did you take,
We're in the same office.
Okay,
So I am not trial counsel. I haven't been involved at the trial level. I'm just handling the appeal, but we're in the same office. And the subpoena that was served on Ms. DePiro was also asking for all of her communications back and forth with Ms. Greer. And the reason that that's immune from discovery is this. It goes more to the attorney work product doctrine than privilege. So you have a situation where there are some ancillary issues involving trust matters. Ms. DePiro, like Mr. Vance, has focused her practice on matrimonial matters, has no expertise in the area of trusts and estates. And so in order to advance certain arguments before the lower court, she did her due diligence. Yes, she conducted research. She did her due diligence. Part of that due diligence involved having discussions with a retained attorney who is more familiar with these issues. And then she asserts arguments.
With the trust and estates issue.
With respect to the trusted estates issue.
Okay, so
Now,
let me just say, for example, so if those comments were isolated, you can have those kind of conversations. If there were conversations involving this custody battle, would those conversations be discoverable or, subpoenaable?
I guess it all depends on whether or not those conversations are in service of representing a common client, because here you have a party that has retained matrimonial counsel and has separately retained trust counsel for the explicit purpose of coordination, so that the matrimonial attorney can discuss issues with the trust and estates attorney, use the trust and estates attorney as a sounding board, so to speak. And so the result of this is that Mr. Pirro asserts certain arguments regarding the trust before the lower court. And now the appellant says, well, I want to see everything that you relied upon in coming up with those legal theories. But the attorney work product doctrine is clear. You don't get to look behind the curtain. You don't get to peek inside an attorney's mind. You're not entitled to insight into how or why they come up with certain arguments. If your contention is that the arguments are incorrect, then assert counter arguments. But the material that's sought here is specifically material that the matrimonial attorney relied upon in representing this client before the lower court. I don't see how that in any way, shape, or form would waive the privilege or waive the attorney work product doctrine. And again, even if this court were to find, no, all of that is waived, still, it's plainly a discovery subpoena, and it was served post note of issue. So that in and of itself would have been more than a sufficient basis for quashing it. I think it would be a stretch to say that the court abused its discretion. So unless.
Thank you, Mr. Clapp. Listen, all set. Thank you.
Thank you.
Mr. Vasilian.
Good morning, Your Honor. May it please the court. Your Honors, I represent the 13 going on 14-year-old daughter of the parties. I want to address the issue of the destruction and the affidavit, if I may. I think it's very clear. I think the question is whether the court's intention was clear or not. And I think the records shows that it was very clear that the court intended the defendant to certify that he's destroyed communications of the children, of specifically my client. I don't think it had any intention, I don't think there was any intention or communication of an intent that every communication should be destroyed and thereby deprive the defendant the ability to use other documents that would be relevant to custody issues. Clearly, the court has the discretion, in fact, I think the duty to ensure that the children's communications, the confidential communications between them and their attorneys are kept out of litigation. And in fact, after I submitted the brief on this, I came across a discussion about a matter that this very court ruled on in 1989. It had echoes of that. And that was the Ladd v. Bellavia case, which is 151 AD 3rd 1015. In that case, the children's confidential communications taken in a Lincoln hearing became discovered or disclosed to the parties. And I think the policy is very clear in that case, as in this case. Once that bell is rung, and use another turn of phrase, once the bridge is burned between the parent and the child and the communications come out, that's not a bridge that's easily repaired. So I think the court was well within its right and well within its discretion to require the parties certify that those records were destroyed as a matter of fact. As far as the in-camera review of records is concerned, again, I also think that was within the court's discretion to do. Clearly, I think the court was very clear that it thought that the connection between the plaintiff, her communication with her OBGYN regarding the blood types and issues relating to my client and the other AFC's client were tenuous at best. And I think she made it very clear in conference that she was going to review those records to determine relevancy. And I think that was well within her discretion, given the highly sensitive nature of those records with respect to the children as well. So I think that goes back to the issue of protecting the interests of the children. I would argue, Your Honors, that frankly, from my client's perspective, she's been involved in this litigation for about a third of her lifetime. And there's nothing more that I would like to see happen on her behalf, that some finality and permanency be achieved. These interlocutory appeals, while I think they raise issues, ultimately don't get us to the goal of resolving this case for these children and giving them peace.
Exactly what I was thinking. What am I hearing about that's getting us any closer to trial? And so I'm glad you put that in words.
Well, when you think, Your Honors, that this matter has been going on for 5, almost 6 years, and the child is now 14, that's in fact almost approaching half of their life on this planet.
And your clients want some permanency.
They do, Your Honor.
Okay.
So thank you. If there's any questions, I'm happy to address those.
I think we're all set, Mr. Facilian.
Thank you, Judge. Thank you.
Good morning, Your Honors. Melissa Cavanero on behalf of the party's younger child.
And how old is she now?
I'm sorry.
How old is she?
11.
Okay.
Almost 12. Your Honor, points 1 and 2 in my brief are interrelated. The requirement of the lower court for Mr. Schwartz and Mrs. Schwartz to sign an affidavit that they don't possess communications, confidential communications or other attorney work product. It's in line with the CPLR. The CPLR requires the destruction of those documents, that evidence, those materials. And Mr. Schwartz admits in his affidavit that he has communications of the mother from her iPad. He admits to it. He admits and puts in evidence conversations he has with Mr. Vasilian's client relative to the litigation. So to say that it's unfair that the court requires him to sign an affidavit that he has never possessed the documents, he clearly admitted that he did. And the CPLR requires it. And just because my client is a child doesn't mean attorney-client privilege doesn't attach. It does. And this court has upheld that privilege attaches to children. And that if there's going to be a waiver, that must be knowing and voluntary. And that didn't happen in this case. Relative to point 3 of my brief, the court properly required the review of the documents that they granted to be subpoenaed to the court in camera. The court probably should have denied the request. The request was at best a fishing expedition. after the court hemmed and hawed about whether or not they should grant that request, but they did. Mr. Schwartz won that point. But the court, after reviewing the documents, which were over 10 years old, and went to the issue of blood type, determined that that wasn't relevant to custody and visitation or any other factor in SBOC. Again, this is just another step prolonging this litigation. It's frustrating that we don't have a trial date until just about 11 months from now. My client, again, went from elementary school to middle school, is figuring herself out and is in limbo in this custody. And she really just needs this matter to be.
So you're telling me that everybody here wants this case to move, but yet we're not moving?
Correct.
I don't know that I could do anything about that, but I find it interesting, okay, and distressing. Okay.
Thank you.
Counselor, thank you very much. We'll
Thank
take a good look at it. Thank you. Okay, last but not least on the calendar, we have 336 and 337. Both counsel are here. Gentlemen, you've made it here just under the wire. Good morning.
I'm glad I can say good morning. May it please the court. Mr. LaRocca was driving, or the only evidence in the record is that Mr. LaRocca was
I
driving.
would say there's a question of fact, Mr. Volz. And again, you waited here this whole morning. I'm going to give you a chance to speak. Don't worry about it. But you're pointing to that 35-mile-an-hour advisory sign.
That's correct.
That highlights the fact that an intersection is coming up. And you're saying that you don't have the right to just brazenly drive through an intersection without any concern for that sign. Seems to be your main argument, but if I'm missing it, please explain it to me. But I want to make sure you know that we're all familiar with the facts.
Okay, that is my main argument. The only evidence in the case of Mr. LaRocca's speed was 52 miles an hour. He attained that speed after he pulled out from the Hanson aggregate. He maintained that speed as he approached the intersection and as he entered the intersection. The lower court's decision said there's no evidence as to his speed, which is an issue finding as opposed to, or I'm sorry, issue resolution as opposed to issue finding. The evidence shows that he was going around 52 miles an hour. The evidence also shows that there was an advisory speed limit. Those cannot be posted willy-nilly. They have to be based on an engineering study or sound engineering judgment. Our expert, Peter Scalia, explained this. Look, it's a weird intersection. It's not a 90-degree angle. There's a difficult view or a difficult sight line for the southbound vehicle, like the Simpson Saab sedan. And it's a difficult view for the westbound vehicles, like Mr. LaRocca's truck. Mr. Scalia gave us the reason, the sound engineering judgment that the 35-mile-an-hour limit was based on. If that's not enough, Mr. LaRocca, in trying to describe or trying to excuse his actions, said, my view was blocked by the tree line. I didn't see him until a split second before the collision. So he confirms the basis for that sound engineering judgment for that 35-mile-an-hour advisory speed limit. Defendants have been saying, hey, the cops didn't give him a ticket and he wasn't speeding because it's 55 miles an hour on that road. Well, VPL 1180 doesn't say you can't go over 55. It says no person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions and having regard to the actual and potential hazards then existing.
What speed is reasonable and prudent? Well, sound engineering judgment, that yellow advisory sign tells us 35 miles an hour.
Okay, so you're trying to tell us we shouldn't ignore that sign. That sign means something, and it creates a question of fact with regard to whether it was complied with, whether it was prudent. It raises a whole host of facts.
Absolutely. It raises a question of fact so that summary judgment should not have been granted in this case. So, I mean, you guys get it, and I appreciate that. Moving on, comparative fault. Well, the defendants are saying, hey, Mr. LaRocca had he had the right to assume that the Simpson sedan would have stopped.
But we don't even get the comparative fault unless they establish as a matter of law that they weren't negligent.
Thank you. Exactly, Your Honor. All of the cases that they cite have a caveat from the Fourth Department saying, if there's no negligence on behalf of the other driver, then he has the right to assume, then we can grant summary judgment against Simpson. But in every one of the cases cited by counsel, they kind of ignore that. And the courts don't. The courts do grant summary judgment when somebody blows a stop sign, because a car has the right to assume, or driver has the right to assume that they won't blow the stop sign. The only time summary judgment is granted, though, is where that driver who assumes the other car won't fail to yield had no negligence.
And so much of this, following up on Justice Bannister's question, so much of this has to do with that advisory sign. As you point out, they don't put signs on highways like this willy-nilly. There's usually a study, et cetera.
That's correct.
If you don't mind, Mr. Volz, I'd like to take at least briefly to both the emergency doctrine and to the statutory exemption. So
The reckless disregard.
yeah.
Yes, exactly. The emergency defense.
It can't be an emergency of your own creating by not slowing down for the 35 miles an hour is the argument I saw in your brief, I think.
Exactly.
And then on the statutory exemption, as I call it, the argument that you've made, not saying that I agree with it necessarily, but the argument you've made is that he wasn't actively working with respect to his function at the time. He was delivering, so he wasn't at the delivery site. And I didn't mean, again, steal your thunder, but I want to make sure you know the panel has taken a good look at everybody's briefs.
Okay. And in fact, the reckless disregard standard is the last one. The courts have really looked at it and said, while, and the phrase that they focus on is while actually engaged in work on a highway. That statute protects the flagman. It protects the people out there, the DOT workers who are out there on a construction site. It doesn't protect the person who said, I'm not sure what route I took the first 3 trips with the asphalt from Hanson to the library parking lot. I don't remember which route I took. I've gone through this route before. It could have been this route, could have been another route. You can't say that the reckless disregard standard should apply when the town doesn't mandate that he go left instead of right.
It's not like the snowplow driver that has a route or whatever.
That's correct.
Okay.
Even where the blade in the snowplow is not down, if he's on the route and inspecting to see when he needs to drop the blade, he is still in the course of his employment and he is still in the activity. He's actually engaged in that highway work.
That's the words I was looking for. Mr. Voltzman's going to take a close look at your arguments.
Thank you.
Thank you. Mr. McLaren, good afternoon.
Good afternoon, Your Honors. Thank you. I'm going to adhere to your admonition to several people that you've read the papers and obviously by the questions you're
You've
familiar
been here the entire day. We're going to listen with
I-
reason. but
I
go ahead.
appreciate that. In response to Justice Bannister's question, to hold that all the plaintiff needs to do is to show that someone exceeded an advisory speed sign is evidence of negligence or some negligence. This would be the first court to ever do that. in the state of New York. Our burden,
I didn't really suggest that.
no. I know you asked the question and
Suggest that it is evidence of an engineer, of somebody to put that up there, that there's some danger to going more than that amount of speed. So.
I would agree that there is, that a warning sign like that and an advisory sign is saying, hey, take a look at this. Take a look at how you're driving. And what we have here, what we established on our motion is you have a bright sunny day, flat road. There's no issue that the traffic was congested or stopped or any other circumstances. You know, it wasn't pouring rain, it wasn't anything. And my driver's driving below the speed limit as he's approaching this intersection. And this is an intersection that's controlled by 2 stop signs. So this idea of like, that he should have slowed down because of the sight lines. The sight lines don't matter when you have a stop sign, because every driver that's approaching that intersection is entitled to assume that that driver is going to stop at the intersection. And that didn't happen.
True, Mr. McLaren, but Mr. Volz in his brief has cited a case from our court that we've said the same thing many times, Pagels versus Mullen. When you, as a defendant in this situation, move for summary judgment, as you know, you've already said so, you bear the burden to show as a matter of law that you were not negligent.
Right.
So you're saying I wasn't negligent because I had the right of way to go through there. But we also have cases that say you can't just ignore the conditions of the road and you have to see what has to be seen. What if the driver's coming down at 90 miles an hour and is clearly not going to stop and you see it? You have a duty to avoid the accident. The other thing that Mr. Volz seems to hang his hat on with respect to rebutting your motion on the negligence issue is, wait a second, your driver didn't even see this 35-mile-an-hour zone, gave it no account whatsoever. Isn't that at least some sliver of a question of fact defeating your reliance on the right of way? That's sort of my loaded question for you, Mr. McClure.
I understand that, and I would go back to say that if in fact this court is prepared to hold that exceeding an advisory speed is negligence or some evidence of negligence, you would be the first court to do that.
You don't have to say that.
Well,
the plaintiff has no burden to establish that in this motion. You have to establish as a matter of law that you were not negligent.
Right. And by establishing that we were going under the speed limit on a nice sunny day, on a flat road, he was paying attention. He wasn't on his cell phone. He wasn't fiddling with a radio. He wasn't distracted by anything, looking straight ahead. He's allowed to assume that they're going to stop. So what more could we say if he's going under the speed limit, paying attention on a beautiful sunny day, paying attention? That, to me, Your Honor, is establishing that we were non-negligent. So then what do they have to do? They have to come back and say, you know what? Well, because of this or this or this, you were negligent. And one of the things they said is, well, their expert comes in and says, well, the sight lines. But he doesn't do a sightline measurement. He doesn't do an evaluation of speed. He doesn't say if you were going 35 miles an hour, you could have stopped with a 10-ton truck in so many feet. He doesn't say that he didn't do an analysis and say the Saab never stopped, which he could have done using crash analysis or reconstruction. There's none of that. All he does is say, well, I think that maybe if he was going slower, he could have avoided this. I mean, my guy testified, and nobody disputes that Simpson pulled out right in front of him. No time to react, hit him, caused him both vehicles to go in the other lane of traffic. I mean, even if you get to sort of, if you think there's a question of fact on negligence, there clearly is not a proximate cause. I mean, the sole proximate cause here.
Pagels versus Mullen says your burden is to establish that you were not negligent as a matter of law. And if negligent, that negligence by your client was not a substantial factor in causing the accident. So when you evaluate proximate cause from that perspective of that case, you essentially have to assume arguendo that you were negligent. So can you do that here and still argue proximate cause?
Yes, because I can say, and I'm not going to repeat it again, that we have established that we weren't negligent. He's driving down the road, paying attention.
But now assume that you were negligent.
Assuming that he was negligent, he's still entitled to assume that that guy's going to stop. And when that guy either doesn't stop or pulls out in front of him, and there's no dispute in the record that he had milliseconds to react, what could he have done? And And once we establish that this was an emergency doctrine, this guy pulls out in front of him unexpectedly. The burden then shifts back to them to say, well, you know what? If he had been going slower, he could have stopped because this is the stopping distance or whatever. We met our burden by one, establishing that this person came out unexpectedly. And I think that that's a given that he's entitled, that's a fact, as a matter of law, that he was entitled to believe that person would stop. So he comes out unexpectedly and he reacted. He did everything he could. I think.
I don't mean to limit your argument, but I hope you know that we, and Mr. Volz too, we've given this case a good look. I'm not trying to cut you off. Would you mind taking me briefly, at least, to the last point about why you think the statutory exemption applies here? Because I'm a little uncertain about that one. And we know the case law. We've had a lot of them. We've all been on cases involving that situation. Why do you think that applies here?
I think that, well, if you look at the Sullivan versus Vestal decision out of the Third Department, that it talks about a truck traveling from one place to another is actually engaged in work on a highway when they're delivering goods from one site to another. And I think that we have that situation here. You've
got that case in your brief for us, right?
It is, yes, Your Honor. It's from 2003, yes. And I think it's more analogous to the snowplow that lifts up his blade and is going from one point to another to plow. This court has held on numerous occasions that that's at work on the highway. And I would disagree with my colleague that the statute is not designed to only prevent the people who are working on the highway. It's designed to protect the municipality, because drivers who are involved in work on a highway, carrying heavy loads, doing things, making turns on and off the roadway at unexpected times are protected from having to take those actions. So I think that if you look at the purpose behind the statute and what was actually happening here, it's an easy conclusion to draw that he was engaged in work on a highway.
Thank you very much.
Thank you, Your Honors.
I'm sure I did.